Welcome to our session on intellectual property for the financial planning firm. I think one area that most financial planners are unaware of completely is intellectual property, such as trademarks, copyrights, patents, etc., which many say, well, that's for manufacturing. And yet, for most cases, what separates a niche from everybody else in the service industry is what we call intellectual property. And I think that the best niches are those in intellectual property, as we'll be discussing. And I hope you get a lot out of this module. And you'll see the importance of not only protecting your intellectual property, but the need for having an attorney or sometimes expertise attorneys who specialize in intellectual property working with you on the activities. So let's first of all look at the objectives for our session. First of all, discuss the various types of intellectual property intangibles. An intangible, again, is something that isn't physical, and these are not physical. Understand the need for copyright of material, describe proper use of non-disclosure agreements, and identify what would be an IP ethics issue. And I might just say when we're talking about this that we are going to be covering emphasis on copyrights, but trademarks and even patents and trade secrets are all applicable for financial planning practitioners. And sometimes we forget about it, especially areas of trade secrets. And so I think you'll get a lot out of this session from the standpoint of your business and protecting your uniqueness. You ask an average person what is it intellectual property, and they'll probably say my phone. And that's not supposed to be a joke, but that's what I've heard several cases. When I ask a person what is intellectual, well, their telephone is very smart, right? So is their computer, but so are the ownership of intangibles. And the way I put it to the client when I hear that is, your phone and your computers are tools for IP. IPs are associated really such as distinguishing of a service or brand. For example, if I say Ford, I think most people think of cars. If I say Scotch tape, people think of adhesives. If I say Microsoft, we think of Windows. Tools precluding others from using. In other words, we can prevent others from stealing our original concepts and our original ideas. And of course, those of you who have completed the CFP programs are aware of the fact that plagiarism is not acceptable in schools, and it certainly isn't acceptable in the public arena either, but we have plagiarism all the time. People see something on the internet, they feel it's open game, they forget that it's copyrighted. And we encourage the arts, which is certainly under all the arts fall under IP, protection of reputations, provider of business opportunities by just having a unique niche that's you can copyright or trademark, etc., and it's capable of having a very substantial economic value that wasn't true 100 years ago, but today, due to the value of such things as software, many of these things that had nominal value in the past have become very important. And with the interface of communications throughout the world, such things as trademarks have become very important. Some IT issues. First of all, we have various laws covering the topic. We have state laws, we have federal laws, and we have other countries. Because many of the things you do with the internet today obviously go well outside the United States. Many of your advertisements through magazines, etc., go outside the United States. Even radio broadcasts that people have on are sometimes going overseas. So we have a great deal of government laws involved because the states, the federal government, and other countries are all trying to protect the rights of the IP, intellectual property. They're also trying to set guidelines, and sometimes it's confusing. especially when states and federal government have this laws on the same topic, such as they do on trademarks. Governments do not aggressively enforce intellectual property rights, and thus the owner must take preventive action and after the fact action. So, if you get robbed, the cops will do something. If you are in a position where someone's taking advantage of you, usually there's a remedy. But when it comes to intellectual property, the government more or less says, well, you have to protect your own property. We're not going to do it for you. So you have to find out who is violating your property rights, and then you have to go bring actions against them. The government doesn't do it for you, which means small companies can't afford the enforcement, and thus, for practical reasons, good IP, intellectual property, is generally sold or leased to larger companies when we're talking about copyrights and patents and many times even trade secrets. Because again, it costs a lot of money to enforce it. Not only enforce it here in the United States, you have to enforce it in any country where it's made or used, and that can be a substantial number of countries where you have to do it. And yes, the big companies can't do it, little companies can. And so sometimes the technology is sold, sometimes it's leased. Sometimes I've seen cases even where a large company serves as a godfather for you. They get benefits from you, and so they say, we will help you assist in tracking to make sure you're not being compromised. All IP has limited life. There's nothing that goes on forever. Now I had people tell me, well, what about trade secrets? Well, trade secret is probably the one that has the most life because it's never told outside the company. But if it gets outside the company, then it has a limited life based on the agreements that's released under. Example of problem areas today we see in IT: fake names on jewelry, clothing, fashion wear. I remember I was on a business trip to Brazil one time, and there was like a catering truck here in the United States for food. There was a truck that had all sorts of watches, and they had every watch said Rolex on it. It looked like a Rolex watch. In fact, looking at it, the only way you could tell it wasn't a Rolex watch is the weight was so light compared to the Rolex, but it sure looked like the real one. And my wife has got a purse once, which we found out was a fake, and she paid quite a bit of money for it. We find misuse and miscopying of software. I have software in the office. I take a copy of it home so I can use it, or I have a copy in the office and I let everybody in the office make copies of it. These are obviously misuses of the software, unless, again, the software agreement calls for it. And I doubt if any of you have ever looked at the software contract you signed when you're buying software, when you're buying the license to the software. You don't buy software, you buy a license. Stealing material from the internet is done all the time, and certainly a lot of the ideas I have from my lectures come out of the internet. I try not to plagiarize it, but I certainly take the concepts and I use it. And we have counterfeit equipment and parts throughout the world today. That's become a big problem in the building of airplanes, where parts look like the correct parts, but it's made by somebody who's probably not met all of the quality requirements, and there's damage to the aircrafts. So we have to areas watching that. Department of Defense of the United States is also very concerned about counterfeit parts that, again, don't perform like they're supposed to. And a good summary is all of these we've talked about here have significant impacts on our culture, on our society, and on our economy. And things we can do as individuals to reduce these types of problems, I think, are very beneficial for our society, and which becomes an ethics issue, right? A personal ethics issue. What we're going to cover in this lecture is trade secrets, trademarks, which is also called branding, copyrights and patents. Patents are not as important for Financial planners are the others, but we want you to understand what they are. Trade secrets, trademarks, and copyrights are very important for any practitioner. Trade secrets. It's the oldest method of intellectual property. It goes back to the Abyssinians and the Babylonians thousands of years prior to the current era. And it was things that somebody knew in advantage to do something that others didn't. Maybe it was a writing style they did. Maybe it was a way they mixed dirt and clay together to make bricks. Maybe it was a way they used building construction to build canals and transferring water from point to point. And certainly in the Italians and Romans had methods of building bridges and roads that are still in use today. It's kind of interesting. In my neighborhood, which is only about 40 years old, we've got all sorts of street cracks, and it's almost a third world country as far as the streets are concerned. And if I go over to parts of Europe where the Romans built roads and bridges, the same were built 2,000 years ago and still in use and look better than we have in the United States. Same way with the sewerage systems in Europe are much older and built by the Romans that are still being used in the United States. We have constant problems of sewerage and water systems. It seems the city of LA every couple of months has a water or sewage breakage. And again, there were proprietary methods they had to doing it. Many of those have been lost in history and have never recovered to the point where we were able to duplicate what they did. In other cases, they did things we probably wouldn't want to use today, like lead. Second point on trade secrets, they're covered by state and federal laws, which vary greatly. And here in California, we have laws just like other states do. And the federal laws are, again, many times different than what the state laws are. And other countries have laws on trade secrets. To me, a trade secret is something you keep within a company that's, so easy to say. But what if an employee leaves and takes it with them? What if an employee has a trade secret they leave on their desk and a client or supplier sees it and takes it? What if the company has a fire and firemen come in and see it and take it? There's all sorts of these things that happen, and what should we protect and not protect? Some states are very protective of proprietary data, trade secrets. If it's stolen, still must be treated as proprietary by the people who receive it. And in other states, if it leaves the facility, either by firemen taking it, clients taking it, it's stolen, whatever, you've lost the trade secret. So great variance in it. The key is to know what the rules are in your state. And again, you need a lawyer to really explain that to you. Recognition outside the United States varies greatly, just as it does here. And very broad coverage and doesn't need to be that unique. In other words, a trade secret could be something very simple, such as how you attach two pieces of paper together, which is unique. And if it's you keep it in your company, no one has to know about it. It might be just using Scotch tape. And if you don't tell anybody, you can call it a trade secret if you want to. And that means it doesn't have to be unique. It's just that you don't let people outside your company to know it. And then it can be very complicated things. Software systems that are used for choosing stock are becoming very popular today. Again, if you keep it within your company, it's proprietary. What it is a problem, and let's see, it says general rule protecting trade secrets is not letting anyone outside the company know about it. Which, again, if it's stolen in the middle of the night, if a fireman takes it, if a client is visiting your business and accidentally can find a copy, if an employee leaves the company, all of these are things we have to say, okay, what's the rules on it? Vehicle for showing trade secrets, outsider, but still disclosing the secrets. still protecting the secrets in many jurisdictions is the non-disclosure agreement. And that is very valuable. I think most of the states in the union today, disclosure agreements, I doubt if they all do, because there are some jurisdictions I dealt with in the past who haven't, and I'm not sure they got to doing it. But these are excellent documents that give protection, and it's been developed to encourage commerce. And I might be dealing with you in a typical situation I run into that might involve financial planners. Would be, I have my proprietary way of doing my stock picks, and I'm going to merge with another financial planner. And in order to show him what I'm bringing to the table, I have to let him know what I'm doing. So I show him what it is and why it's unique. Well, if our deal goes through, that's not a problem. But let's say our deal doesn't go through, it falls apart. Can I protect myself? And again, that's where the non-disclosure agreements come in. Non-disclosure, use other names. It can be called a confidentiality agreement. It can be called a proprietary information agreement, and you can call it a widget if you want. The key thing is it protects data from being distributed outside the contents of the non-disclosure agreement, which might be simply that you can look at it while you're in our facility, or you can look at it and take a copy with you, but you don't show it to anybody, and you don't use it. So there's all sorts of things you can have in the agreement as far as what can be done. The key thing, again, is you keep it so that you retain the ownership and people cannot use it without your permission. And agreements should not be used without legal review due to various laws covering the protection, and also antitrust laws get involved too. So don't try to be creative in coming up with a non-disclosure agreement. Get one from an attorney that meets all the legal requirements of your particular jurisdiction. Now, if you're in areas like the tri-state area, where you're going to do a work over state lines, your attorneys have to look at the states you're going to be doing business with. Or if you do work, say you have clients in Colorado and Arizona as well as California, and for my case, I had clients in Arizona and Colorado, I had to make sure their rules were being met as well as mine, and there again need for legal advice. Trademarks. A trademark is a legal name, but commercially many times refer to it as branding. Definition of trademarks is a name, term, design, symbol, or other feature that identifies one's goods or services as distinct from other sellers. And ones I think we all know, the Golden Arches. I think everybody thinks of McDonald's. Big Blue, if you're my age, we think of IBM. Or University of Michigan, depending on where you're from. And the symbols on cars today. You look at the car and you don't even have to see the name of the car. You just see the symbols on it, and like the Mercedes on the front hood, etc., and you know what brand it is. And we use trademarks to distinguish ourselves. And we have laws, again, by state governments, by federal governments, and by foreign governments. We always got a lot of laws, don't we? And again, we want to be able to protect our identity. In the United States, trademarks are registered with government offices. They're registered with state offices generally. It's considered banyan if you don't use them. And I actually have a case in my family where I have a daughter who started an electric company in Washington State, and they live in the city of Maple Valley, so they were going to use the name Maple Valley. Well, it turned out there was recorded a company named Maple Valley Electric, and her first response was, well, I guess I can't use it. She checked with a lawyer, and he said, sure, you can use it. They haven't used it for 20 years. So if you don't use it, you lose it, is a good way of putting it. So the mere fact that you registered something, if you don't use it, you're not going to be able to protect it. And it's restricted to the marketing area of the business. For example, when McDonald's started out here in California, they had the Golden Arches, But at the same time, there's a company in Florida who had golden arches. There was some kind of food company, and there was a company in Israel that had it. And the McDonald's, when they got closer to those areas, were starting to infringe on the territorial use in Florida and Israel. They had to either not go there or buy out the companies. So you can think of two companies, one in Florida and one in Israel, that made a lot of money because McDonald's wanted to be able to be the sole user of the golden arches in those areas. And that's not unheard of for other companies doing the same thing, seeing something that's growing in one part of the country and then using the name in a different part of the country and waiting for that marketing to come there to buy out your titles so that they can be nationwide. Final point here is cases where trademarks were allowed to become generic due to lack of owner enforcement include Kleenex and Scotch tape. For those of you a little older, you may have heard of Kelvinator refrigerators. For many times, a Kelvinator meant it was a refrigerator. So you have to be careful on how it's used. I think when SUVs came out, there was one company called SUV, but they didn't watch it, and so all of a sudden everybody can use the term SUV. It's another good example of it. And so who enforces it? Your company has to enforce it. So let's say you take your name, Thousand Oaks Financials. You have to protect that. If someone else is infringing, you have to stop them from infringing in your territory. Now, if they use the name in New York and you're only doing it in Southern California, that's the right. Now, if you grow as a company and eventually you get to New York, you're going to have to buy them out, right? But what you want to avoid is Thousand Oaks Financials doesn't become a generic term for financial planners. And that's things that Scotch tape and Kleenex didn't really work on good enough. They want you to say Kleenex brand tissues, Scotch brand adhesives, and of course anybody Rolex watches for quality watches, I think is a good example. Gucci purses, they've been able to retain their names, and so it hasn't become generic. When a company has a name other than the name of the owner, it is a fictitious business name that must be registered. For example, Joe Smith owns Thousand Oaks Insurance and Casualty Company. Assuming the market is only Thousand Oaks, parties in other parts of the country can register the same name for their business. But one cannot trademark the name as a business, say Joe Smith Insurance and Casualty Company, and then prevent others from using the name to try to mislead the public. So if I had Joe Smith Casualty, and then someone else had the name Joe Smith and a casualty company, that's their name. They should be able to use their name. And so therefore we do have situations where in a city the common names like Bob Smith might be 4 plumbers with those names, all of which would like to trademark it, but they can't really because we're allowed to use our own names. And as long as it's not a fictitious name, like Thousand Oaks Insurance, but it's called Joe Smith Insurance, you can't really protect it. And that is one reason why if you want to build up an identity, it is best not to use your name for your business, but something that is going to be a fictitious name, because then you can protect that name from other people using it in your marketing area. Where if you're using your own name, like Joe Smith, insurance, anybody named Joe Smith can use it. Now, can they change their name to Joe Smith to be able to do it? I have no idea. You'd have to ask your attorney on that. Some more on trademarks. In recent years, the websites are expanding the trademarks, names, symbols, etc. to larger markets. Clearly, an attorney is needed for those who are serious in protecting their trademark and marketing areas. And that's as we have the internet today. I'm having people saying they're getting clients in Europe and Asia as part of their financial planning practice. That, quite honestly, does affect the businesses, and quite honestly, is making it more important than ever to be able to control and police that trademark, so that worldwide you may want to have it trademarked, and that means a very big financial cost, and of course naturally you got to start off with getting legal advice in that area.